Chapter 9 is on real property ownership. The word title implies ownership, or at least that you have an interest in real property. There are several ways that we can acquire title. A deed, first of all a deed is a conveyance instrument from one person to the next. The deed is probably the most common way that we attain title. Another way that we attain title is through something called a will. Anytime that a person dies testate, they're said to have died with a will. In other words, they are in writing stating where they want their real and personal property to go. If a person, however, dies intestate, that means that they die without a will. Now, that causes a problem, because now where do their things go? Where do their real and personal property go? Well, it goes to their closest heirs through something called descent and distribution. The problem is it's a long legal process, or can be, because you could have all kinds of people making claims on it. Another way that title transfers is through escheat, but let me say this. Escheat is not what you think. If a person dies intestate and has no heirs, it has to go somewhere. It will go to the state of Florida, and the state of Florida then will decide on its disposition. Another way that title can transfer from a person, whether they like it or not, is through a process known as eminent domain. Eminent domain is the process where the government can take a person's property as long as for public good or for public use. Oftentimes we use it to take property for roads and other things of that nature. Adverse possession can occur in rare occasions. And let me tell you what adverse possession is. If somebody comes in and openly and hostilely takes over your property, and they live on it for at least 7 years, the way it was back when it was created, they might be able to take title to your property. Well, things have changed since then, because the test today is who is paying the property taxes. As long as the true owner is still paying property taxes, adverse possession cannot occur. And also keep in mind, when this law was created, we didn't have real estate taxes. Today, if you don't pay your real estate taxes, it goes to a public auction. And so this process, the 7-year process, honestly cannot occur today. Notice to title. Now, there's 2 ways that we make notice to title. One is actual notice, and the other is constructive notice. Now, let me do constructive notice first. Constructive notice is when we record a deed or any legal instrument on public record. We're letting the world know that we have something that is now public notice. Actual notice is when you physically do something. Now, listen very closely. Title to real property transfers when the deed is delivered and accepted at the closing table. That means that a deed actually transfers, or title transfers, through actual notice, where here's the deed, thank you, please. A deed does not have to be recorded on public record for title to transfer. But we do it only to protect ourselves. So we give both actual notice and constructive notice when title transfers. Protecting title is going to be important. When you're buying a piece of real estate, you want to make sure that you have clear title to the property. And there are a number of ways that we go about it. Long time ago, we had things called abstracts. And an abstract was created that went all the way back to when that property first came into service for the United States government and then into the private sector. Since that time, abstracts really aren't used that much anymore. And what we had contained in that abstract was a chain of title. Well, today, basically, that's what we're looking for. The Marketable Records Title Act changed everything back in the mid-1980s here in Florida. Now we only have to do electronic title searches back 30 years to clear title. So that old abstract that went back to day one is no longer a necessity in clearing title. There's 2 kinds of title insurance policies: the owner's policies and the mortgagee or lender policy. The owner's policy is, first of all, not transferable, and it's based on the purchase price or their equity in the property. The lender's policy or the mortgagee policy is transferable, and it's based on the loan amount. And the reason that it's transferable is that most of your banks are going to take that mortgage and note and sell it to an investor. Therefore, that policy will follow or trail with wherever that mortgage and note goes. The deeds that are going to be involved, there are several kinds of deeds, but I want you to remember, in the big scheme of things in real estate or anything, ORs are always the givers, the EEs are always the receivers. So the giver is the grantor, the receiver is the grantee. And in a deed, there are a number of elements that are going to go along with that. You're going to have to, first of all, have the name of the grantor. You're going to have the name of the grantee in there. There's going to be some type of recital of consideration. Usually what you put in there is for $10 in other good and valuable consideration. There's also going to be a granting clause. That's where you're giving it. And there's also going to be an addendum clause. That's your having to hold. And what that contains is the type of estate. Remember that in 99 and 44, 100% of the time, it's going to be a fee simple estate. There's also going to be a reserving clause or addendum clause. And then it might talk about appurtenance. Appurtenance are those things other than the main focal of the sale. Remember that title transfers when the deed is delivered and accepted. Also, a valid deed needs to be signed by the grantor with 2 witnesses and needs to be notarized to be recorded on public record. But let me say this, a deed does not have to be notarized for it to be legal. All that's required is a signature by the grantor with 2 witnesses. That's how you do conveyance. But if you're going to record it, then you have it acknowledged or you have it notarized. Now, what are the statutory deeds that we deal with? First of all, there is a quitclaim deed. A quitclaim deed is a deed that's real easy, and all it says that if I have any interest in the property, I'm giving it to you. It has no warrant of season, and all that is a statement of ownership. It simply says that if I own it or have an interest, I'm giving it to you. If I don't, I can't. Quitclaim deeds are used in curing defects in title, but they can also be used in divorces. And what I mean by that is that in a divorce, if one party has to give up their interest to the other, they simply say, I'm going to give you a quitclaim deed, I'm going to give you whatever I have, but don't come back to me later if there's a problem. Other types of deeds include bargain and sale deeds and special warranty deeds. Now, a special warranty deed is given typically by banks where they're only willing to warrant the property for the time that they actually owned it. Now, if they sell it to you, you can sell it with any kind of deed that you want to, because their warrant time is not the same as your warrant time. They're 2 separate issues. But if you want to sell it with a special warranty, all you're doing is saying, I'm only going to warrant for the numbers of years or the dates that I've owned it. But the most common deed that we have is called the general warranty deed. That's what most people expect. And it contains all the warrants. It contains a warrant of season. It contains everything about the property that we're willing to defend it. And anytime that a person gives a general warranty deed, what they're saying is that if there's any issues with title for as long as I've owned it or anybody before me, I'll cut you a check to fix it. That's what a general warranty deed says. And that's why we take out title insurance, to make sure that we're protected in case there is a problem. Now, a couple of other deeds that we deal with is the guardian's deed and the committee's deed. Now, a guardian, a minor can receive title, they simply can't transfer title. The same thing with somebody that's been committed, somebody that's mentally unstable. Other types of limitations and restrictions, there are government restrictions. Remember that the government has police powers, and all a police power is to make sure that the public is not in harm's way. Zoning ordinances are a great example of police powers. We've already talked about eminent domain. That's where government has the right to take property for public benefits, supposedly. Taxation is also a government limitation. Obviously, if they're taxing your property, that limits you to a certain degree. Now, what are some of the private limitations? What about a deed restriction? And all a deed restriction is, think about a restrictive covenant and a subdivision where they're restricting certain uses. That's what a deed restriction is. And as long as it's legal, you can do it. An easement, and by the way, government can have easements as well, but more of the easements are in the private sector. And all an easement is the right that somebody has to come across your property. And there are several kinds of easements. Just remember that an easement by necessity means that a person cannot be landlocked. The types of leases that we have, and remember, a lease is also an encumbrance on a property. It's giving somebody the right of use, isn't it? So the different kinds of leases that we have a gross lease. This is more common in an apartment. The tenant pays rent, landlord pays expenses. The net lease is found more in commercial properties. The tenant not only pays rent, but the tenant will also pay a portion of the expenses, and maybe all of them. A percentage lease, we find these in shopping centers where the tenant pays rent, but they're also going to pay a percentage of their gross revenues perhaps. And then you got your ground lease. That's where you're renting the dirt. I want you to know the difference between assignment and sublease. Anytime that you assign a lease to somebody else, or assign a property, or sign a contract, assign anything, what you're doing is you're giving up all of what you have to somebody else. A full assignment. Now that doesn't necessarily make you off the hook. You still may be responsible. A sublease, on the other hand, is where you're giving up less than everything you have. Let me give you an example of both. I just leased a condominium out on Naples Beach, and I've decided that it's a 1-year lease, and I've decided I don't want to be there anymore after 3 months. I want somebody to come in and take over my lease in its entirety. That's called an assignment. Now, I'm not necessarily off the hook because I may still be on the hook for the payments unless that landlord gives me novation. But if I decide to lease out one of my bedrooms, I'm leasing out less than everything I have. That's considered to be a sublease. A lien is also a restriction. A lien is simply a sign of a debt, and it's typically recorded on public record. And there are all kinds of liens: mortgage liens, judgment liens, mechanics liens, real estate tax liens, federal income tax liens, and special assessment liens. Now, this special assessment is government liens, where they go in and pave properties and, or pave streets in front of your property, things of that nature. And I think that's all I'm going to be covering in Chapter 9, Real Estate Property Ownership. It's a nice little chapter. You need to go back and look over it. But what I'd like to do right now, let's go ahead and get into our review on this particular chapter. Chapter 9, Real Property Ownership. Constructive notice is recording on public record. Licensee should not give opinions of title. Leave that to a professional, perhaps a real estate attorney. The chain of title is ownership and usually is found in the abstract. The grantor is the giver of the deed, and they have to be competent, and that is to say they need to be at least 18 years or older and mentally competent. The habendum clause identifies the type of estate. The granting clause has words of conveyance. Failing to record a deed may cause a person to be estopped or prevented from their ownership. Remember, you don't have to record a deed. It's just good business to record your deed. The warrant of season is a declaration of ownership. It's found in every deed except the quitclaim deed. Police powers include zoning laws. Government limitations include eminent domain. Private limitations include deed restrictions. An assignment of lease gives up everything that a person has remaining in a lease. A mechanic's lien is effective when the materials are first delivered, but does not have to be recorded for 90 days after the work was done. A mechanic's lien can foreclose a homestead. The general warranty deed provides the most protection for a buyer, and actually it provides the most protection for a seller as well. The mortgage lien is an example of a voluntary lien. A real estate tax lien and special assessment lien are considered to be superior, and what I mean by that is They will take precedence over any other lien recorded. Owner's title insurance is not transferable. Each new owner has to get their own policy. The lender's title insurance is transferable because that insurance policy follows the mortgage note wherever it's sold. And that's all I've got for Chapter 9, Real Property Ownership.